like Athena sprang from the head of Zeus, great ideas spring from the head of Diane Young. And she's going to share some of those with us this morning with her phenomenal team. Diane?
Great, thank you so much. Can you all hear me okay? Fabulous. I'm just going to switch over and start sharing my screen, so bear with me for 2 seconds. There we go. Can you see my screen? The generation squeeze. Okay, it's not having its usual cast. So thank you so much, everyone, Chris Kelly and Jen, for having me in and allowing us to bring our program, Generation Squeeze, to all of you. This is, he mentioned, sprang out of my creative brain a few years ago. I've been in the financial services business for 30 years. And about 6 years ago, I had this horrifying vision of a freight train of an aging population coming not only at our society, but myself. And I decided it's such a touchy subject, you know, the sandwich generation, dealing with all the problems that come along with it. And I like to approach all my problems in life through humor. So about 5 years ago, we shot our own little Modern Family spoof called Generation Squeeze. And the reason I did it is that no one likes to talk about the skeletons in their family closet. People are embarrassed. They often think that they're the only ones that have this problem. So I wanted to create a fictitious family that we could use to help us identify the various problems in our lives, so that instead of someone having to say, well, I have a deadbeat brother, or I have this, we can go, well, tell us about how we'd handle this problem based on that character in your little spoof of a TV show. So normally this is about a 2-hour presentation, and we kind of just edited down a few topical things to kind of help walk through a few issues for you guys. So our agenda today is we're going to meet the team. We're going to meet the D family. That's our fictitious family. We're going to talk about what basic estate planning documents you should have. We're going to get into some more deep problems with our fictitious family. We're going to talk about how to protect the family from some financial abuse. And then we'll wrap up with understanding your estate planning team. So as you mentioned, I'm Diane Young. That's the pretty Photoshop version of me. And I founded the Athena Financial Group in 2004, and we are a fiduciary-based financial planning firm, which means we only work for our clients. We don't have sales goals or some corporate overlord telling us what to do. So it's a great way to run a business. Also on the call today, we have Dan Casey, who is our Vice President of Investments and Planning. And then we have 2 attorneys. We have Michelle McRee, who is an estate planning attorney out of the Lapeer area, but she handles a lot of our clients all over the area. And of course, now that everyone is so used to doing Zoom and that, we can do meetings all over. It's wonderful. And then we also have Brian Rude on the call here. And Brian's got himself a nice COVID beard going there, so I love it. He's also an estate planning attorney, and he has a particular focus in real estate. So let's start with meeting our family. So this is our the D family. On the left, we have Grandpa Dad here. We have Danielle. We have the patriarch, Don, and then the matriarch, who is the kind of the center of our story here, Debbie, her mother Dot, and her mother's boyfriend Dino. And then in the photo, we have her son, their son Daniel, and his wife Dharma and Dakota. So we're going to start by watching a quick introduction video of the family, and hopefully this will work.
Want me to go first? Well, I am retired. Thankfully, I was in the auto business for a number of years, and happy to be home and retired.
And I was a stay-at-home mom for many years. I do have an MBA though. And then a few years ago, when my daughter Danielle was in high school, I started a jewelry business.
So we talked to your sister.
Yeah, Debbie?
Yeah, Debbie seems to be doing pretty well with jewelry business.
Yeah, her and her jewelry. Yeah, Debbie thinks, you know, everything just kind of falls in Debbie's lap. You know, she married the nice guy from college. You know, he's such a great guy, great job. They got a great house, but, you know, not everything's always so great with them. So we have 2 children. Our oldest is 30 years old. He lives in California. His name is Daniel, and he's a doctor. We're so proud of him. And then his wife, Dharma, and then their little baby, Dakota, who's a doll, but he's got Down syndrome, so a little special needs there. But he's a sweetie, isn't he, Dakota?
He is, but I don't get Dakota. Why would you name a kid after a state? I mean, I love him, don't get me wrong, great kid. And
They're California. It's just
the California thing.
I don't know. I mean, her name's Dharma.
Is Daniel your only child?
No, we have a daughter.
Yes, our little girl, Danielle.
Yeah, our little girl is 22. She dropped out of college, and she's sitting on her couch most of the time. It's great. Having her own all the time.
She lives at home with us. She's kind of trying to find her way, like a lot of young women her age, and
She just needs to get her act together. I'm sorry, I'm just getting a little tired. She doesn't help out around the house. She's not doing any laundry. It's really starting to get on the nerves.
I understand it. It's kind of a mother-daughter thing a little bit, but I think she's doing great. She's on her way. Very proud of her little girl.
Proud of a 22-year-old college dropout. That's great. That's great. So you've met the family. You can probably already sense some little tension. Normally when we do this workshop and we have a longer period of time, we actually have a therapist as one of our panel speakers, because a lot of the things, we can draft all the legal documents and put all the plans together. But if you don't know how to have that conversation with your spouse about the tensions, in this case, the husband's retired and he's all ready to, play golf all day. And now the wife is finally feels like she's ready to launch, right? She's got rid of the kids supposedly. And now she's got, a husband who wants to stay at home. So we often see this tension play out in relationships, especially when a couple is reaching, let's say, their 50s and they have aging parents and younger children. But let's start off by talking about some estate planning. So before I bring in Michelle to talk about some basic documents, we talk about how assets fall when you pass away. If you die and you own something joint with someone else, it goes to that person. So if I own an account with my husband and he dies, I'm the new owner of the account. It does not go through probate. It does not go through the will. Joint accounts transfer on death, which is a new thing in Michigan. We didn't have those before. So you can have a bank account in which you have a transfer on death. So if you die, then it goes to whoever you named as a quote unquote kind of a beneficiary. Beneficiaries are on your IRAs, annuities, 401k plans, retirement plans. So if you name a beneficiary on that account, it goes to them. It does not go through the will. A trust, which we're going to spend a lot of time on in a little bit, is a form of ownership, and it's basically, I view it as a bucket in which you can put assets into that bucket, into the trust, and then that avoids probate and that. And then finally, anything that's left over gets mopped up by the will. So let's turn it over to Michelle, and she will start talking about how a will works.
All right, good morning, everyone. My name is Michelle. So what is the will? I actually get this question a lot because there's some confusion about the difference between a will and a trust. So what is a will? A will is nothing more than a legal document that directs where your assets will go after you die. And kind of bouncing off of what Diane said, there's 3 buckets. There's the assets that are going to fall in that joint ownership bucket. There's the assets that are going to fall in that beneficiary designated bucket. And then there's the assets that are going to fall in the probate bucket. Whatever assets are not joint owned or beneficiary designated are going to fall in that probate bucket. And those are the assets that will pass through your will. So one thing to be aware of is that not all writings meet the requirements of a will. Just because you write down on a piece of paper who you want to get your stuff doesn't necessarily mean that that's going to be valid under the law. So what does a will do? A will says who will administer your estate. A lot of people call this person the executor. In Michigan, this person's actually called the personal representative. Same thing, just a different term of art that we use in Michigan. So the will nominates guardians if you have minor children. That's a really, really important provision of a will for parents. Who's going to take care of your kids if something happens to you. And then the will says who gets what. It keeps your family out of conflict, hopefully, by saying who's going to get what. But what does a will not do? Wills do not avoid the probate process. And we are going to talk more about the probate process in just a few minutes. But the probate process is what is going to ultimately distribute all of those assets that fall in that probate bucket. One thing I always say is where there's a will, there's a probate. Wills may keep your family out of conflict, but wills will not keep your family out of court. What happens if you die with a will? Your personal representative, who's a nominated person in your will document, is going to initiate the probate process by opening your estate in the probate court. And they're going to follow all of the steps laid out by Michigan state law to pass your assets on to the beneficiaries according to your wishes. And I always I'll save the rest for probate. So we'll talk about the rest of probate in a minute here.
Okay.
If you die without a will, your personal representative is going to initiate the probate process by opening your estate in the probate court. They're going to follow all of those steps laid out by Michigan state law to pass your assets on to whoever is entitled to receive them under the laws of intestacy, which is the fancy word for the laws of dying without a will. So I hope you guys, if you choose to not do any estate planning, you like everyone in your family, because ultimately at the end of that probate process, if you've done no will directing where your assets are going to go, it's going to go to family members who you may not want to get your stuff.
Okay. Brian, why don't you take us through powers of attorney? There's different kinds of powers of attorney, and they're very important for the estate planning process.
Yes. Good morning. Can everyone hear me okay? Okay. Yep. My name is Brian Rude. So with the powers of attorney, these are documents that are going to be used while you're living. You know, having a will, having a trust, all these things that tend to allocate where your assets are going to go is going to be after the fact, after you pass, to make sure that everything is how you want it and distributed appropriately. But what about when you're still living? Who is going to make these decisions for you when you are unable to? And that's why these documents become very important. A lot of times they're glossed over in estate planning, but you want the right people making those decisions for you when you're not in a position to. So it's kind of two-pronged. They're not just one document, but you have one that's we call the durable power of attorney, and this is where you are appointing an agent to manage any of your financial affairs, business affairs, dealing with Secretary of State, doing your banking for you, doing real estate transactions, anything to have to do with your money, you are appointing a person to do this. Now we have two different kinds. The first kind is what we call an effective immediately. As soon as you sign that document appointing an agent, whether it's a spouse or a child or anyone else, they can take that document to the bank and open up an account or make a transaction for you. The other type is what we call a springing power of attorney. And this is maybe one you're more familiar with, and it states that this document is only effective if a couple of doctors say, hey, you're not able to make your own decisions, whether you're in a coma or maybe dementia comes in, just some sort of medical reason that says that you're not able to handle your own affairs, then that document comes into play. Typically when I do estate planning with my clients, I always recommend the effective immediately, because when you want that when you need that document, you want to have it right away. A lot of times people have reservations about handing off power to someone to make those types of decisions for you. My response to that is, if you trust them when you're not able to make those decisions, you should be able to trust them while you can make those decisions.
Brian,
Yes.
so let me ask you a question, because this actually, everything, I meant to mention, everything that happened in this video that I filmed 5 years ago, all the problems have happened to me in real life since then. So in one shape or form or another. So when you have a power of attorney, and it's effective immediately, the person that issues the power of attorney can rescind it, correct?
Oh yeah, you can always rescind your power of attorney. Absolutely.
But what happened in this case is I was given power of attorney on an uncle of mine, and he went into the bank and rescinded it. He had dementia, and the bank took that for fact, and then his crazy daughter that we were trying to protect the assets from went in with him and, you know, cleared out the bank account. So is there a way to protect that? Like, how could I have protected that? My biggest
well,
is how do we protect ourselves from ourselves?
and that can be a tough question there, because what I typically recommend with the power of attorney is that you physically take it to the bank with you to say, hey, put this on file. And that way the bank knows that it's you doing it and it's not just some person walking in with this document. It gets tricky when you have a situation where this person has dementia and they come in with maybe someone with intentions that are, you know, not positive. You know, it has to be somewhat on the bank to, you know, look at and judge on that situation. If they think everything is up to snuff, then the only other action that you can really do is to go down to probate court and try to get a conservatorship, because what this person has done when they truck in their grandparent that has dementia to pull out some funds, I mean, they're committing fraud essentially. Right.
Yeah.
So
okay. We'll talk a little bit about that, but and that's where court can be effective.
Yes, and you hope that you don't ever have to go that way, and that's kind of why you make these documents, and we'll talk about that in a moment. But there's only so much, I guess, we can do without, you know, these people that try to come in and sneak in and take advantage of the elderly. Okay, so let's see, where were we here? Okay, so we talked about the durable power of attorney. That's the document used with the financial matters, but what about those medical matters? And that here in Michigan we call the patient advocate. And this is the form that we use where you're appointing someone to make those medical decisions on your behalf when you are unable to. So unlike the durable power of attorney where it can be effective immediately, or the springing we discussed, the patient advocate is only going to be active when you are unable to make your own medical decisions. So as long as you're competent to do so, you're the one calling that shot. But if you're unable to, that's when you want to designate that patient advocate to act on your behalf.
Brian, and if this is where you would, and again, I know this, my mom passed away last year. I had to keep these forms literally on the table so that whenever you know, someone would call the 911 to have the ambulance come or something like that, to have the DNR, right? The do not resuscitate.
Yes.
And that's a face every time.
Right, and that's a document I always include with that patient advocate, is that DNR, where you really go through and you say kind of what kind of treatment do you want in the event that the doctor is saying brain activity has ceased, there's no chance of you coming back. Do you want that forced tube feeding? Do you want that hydration, the CPR, or do you just want to be made comfortable and glide off into the abyss? So that is always a document that I pair with that, so the client can let the patient advocate know this is kind of what I want in this type of situation.
And my only to the audience out there is that these documents should not be sitting in a locked box somewhere where no one knows where they're at.
No.
Very handy, and especially if you at the end of things, kept very handy, because if someone calls 911, which happened in this case, if I wasn't there to push it into the face of the medical people, they would do whatever they have to do to resuscitate someone. So
right, yeah, I don't want people to confuse an emergency situation with a you know, sort of vegetative state situation. If there's an emergency, then obviously the people are going to do whatever they can to bring you back. So these are kind of two different scenarios.
Right. Yeah. All right. Go
ahead. So we kind of touched on this a little bit, but you know, a big question comes about, like, what if I don't have these documents? What if I haven't appointed a durable power of attorney? What if I haven't appointed a patient advocate? And then they're comes that situation where maybe you need someone to make those decisions, either about your finances or about your medical decision. So if you don't have these documents, that's unfortunately when we need to get the probate court involved. And I'm sure you've heard the terms around guardianship, conservatorship, and these are just terms of art that we use in the legal world. In terms of guardian, that's the person that's making your decisions for your care, custody, medical treatment, and the conservatorship is the person that is appointed to manage your financial affairs. That process can either be, quick and easy. If everyone's on the same page, we go down the court, we file the appropriate documents, we get in front of a judge and say, hey, we're all on the same page. All the interested parties have been notified of this. Everyone consents to this action. Let's get this put this on paper. On the flip side, there, like in any court proceedings, there can be contention. And if you have people arguing, now we have hearings in front of the judge. We have the judge making this decision about who's the appropriate person to make the call. We potentially have what's called a guardian ad litem coming in to represent the best interest of the actual individual who this is we're in front for. So it could be easy or it could be difficult. So it just depends. So I always say, let's not let the judge decide this. Let's get these documents done. So you're the one making that decision now.
Great, thank you.
Yep.
And just to remind our audience, if you do have a question, put it in the chat box, and Chris Kelly and the team there will curate them and get them to us. Okay, Michelle.
Okay, so we touched on what a will does. A will does not keep your family out of court, but hopes to keep them out of conflict by saying where your assets are going to go. Wills are subject to the probate process. What's the alternative if you don't want your family to go to court, you don't want your family to have to go through probate? And the answer to that is the revocable living trust. So what is a trust? A trust is an agreement by you, with you, for your benefit during your life and for the benefit of the beneficiaries after you die. That's all it is an agreement. What does it do? It holds your assets like a little red wagon holding all of your stuff. And anything in this little red wagon, anything retitled out of your name individually and into your name as trustee of your trust is going to sit in this little red wagon, and it's going to avoid probate after you die. Your successor trustee is going to be able to pull that little red wagon right past the probate court and distribute your assets according to the terms of the trust. How does a living trust work? Like I said, you retitle your assets out of your individual name and into your name as trustee of your trust. You are trustee during your lifetime. You have full control. A common misconception I hear from a lot of clients, or a concern, is that, well, if I take all of my stuff out of my name and put it into the name of my trustee of my trust, I'm going to lose control of my assets. No, you are not, because as long as you're living, you are the trustee of your trust. You have full control. You can take things out of your trust. You can put things in your trust. You can sell your property. You can give your property away. You can terminate your whole trust altogether. You can change the terms of your trust. During your lifetime, you have full control. So you pick someone who you know and who you trust to be trustee after your death. They take the pen. And the reason I use that hypothetical, they take the pen, we haven't talked about probate yet, but we're going to, is in order to make an asset transfer out of your name and into somebody else's name, you have to sign your name. If you're deceased, you can't sign your name. That's why the probate courts have to get involved. But when you've put your assets in your trust, and your trustee is the one with the authority to sign that asset transfer, well, now your next trustee after you're gone has that authority. They took your pen. They can sign all of the asset transfers on your behalf into the name of whoever you've chosen in your trust to receive your property. The benefits of a trust are full control. You get to say who's in charge, who that trustee is. You get to say who gets what. You get to say when and how they get it. And what I mean by that, for example, if you're a parent with minor children, you're not necessarily planning on dying, but you need to be prepared. And if you were to die while your children were still minors, you wouldn't want them to receive a large inheritance as a minor, because first of all, the courts won't allow them to receive that. They would be forced into a conservatorship where the court appoints who's going to manage their money. But you also don't want your 18-year-old getting a large sum of money outright when that conservatorship terminates at age 18. So now there's an 18-year-old spending money the way an 18-year-old does with no oversight, no control. You don't want that to happen. So the beauty of a trust is that you can say the age or stage that your beneficiaries are going to get their inheritance. So for example, you can say, when my child turns 25, they get half of their inheritance. They'll get the other half of their inheritance when they're 30. So you can make sure that they're going to receive their money at an age where they're financially responsible enough to do so. Now, just because you're saying that they're not going to get their inheritance until they're 25 or 30, doesn't mean that they're not going to benefit from the money that you've left them. Your trustee is going to make sure that until your children actually receive their inheritance outright, that their health, educational, maintenance, and support needs are all met using the money within the trust. Your trustee has the authority to give them the money they need for these necessities, but doesn't have to give them any money to actually put in their pocket, put in their bank account until you say. So you have full control. And then again, the biggest benefit, of course, is that the trust is going to avoid probate. You can also use trusts to incentivize. So you could put in your trust that if my child graduates college, they get a portion of their inheritance early. You can use a trust to protect your child from themselves. You can put provisions that say if my child has a mental health issue or a substance abuse issue, they do not receive their inheritance until that issue is resolved. So you can build in protections and incentives in your trust document. Another common misconception I hear is, well, do I have enough assets for a trust? Am I old enough for a trust? And the answer is absolutely. If you have anybody or anything that you love in this life, then a trust is right for you. Everyone can benefit from a trust. There's really no downside to a trust. And that's going to really stand out to you guys, I think, a lot more when we hear about all the downsides of probate.
And before we move on to probate, one area I find that trusts really are effective is when you have a blended family where couples, you know, obviously divorced, 50% of us get divorced. I haven't, but you know, and then you remarry and each have children from a previous marriage. You want to kind of protect those inheritances for your children. So that's where trust can really be beneficial. Okay, let's talk about probate.
Okay, so what is probate? Probate is the court process that assets titled in your name at the time you die have to go through to get out of your name and into the name of whoever is ultimately going to receive them. And I always like to remind people, where there's a will, there is a probate. And the hypothesis I always use, why is hypothetical, not hypothesis. The hypothetical I always use is when answering why is probate necessary is because of that asset transfer. You, during your lifetime, if you want to give an asset to someone else, the only way you can do that is through your signature. If I want to give my bank account to Diane, the only way that asset transfer is going to happen is if I sign my name. If I'm deceased, I can't sign my name. So the court has to step into my shoes and go through this elaborate process laid out by Michigan state law to make that asset transfer on behalf of the deceased person. What assets have to go through probate? Think back to those three buckets. You've got the beneficiary designated assets, which will avoid probate. You've got the jointly owned assets, which will avoid probate, but everything else is going to fall in that probate bucket and is going to have to go through the probate process. Why should you want to avoid probate? So these are sort of the three biggest less than desirable characteristics about probate, although I don't think probate has any desirable characteristics. These are the reasons people generally like to avoid probate. Number one, it's long. The fastest it can happen in Michigan is 6 months, and that is best case scenario, all the stars are aligned. On average, it's more of 1.5 to 2 years, and even more if anybody's arguing or fighting over the administration of your estate. When I was doing probate litigation, I had estates open for 10 plus years of family members just fighting and arguing, paying attorneys, and battling in the court systems. You can get stuck in probate for quite some time. Probate is very expensive. On average, it's about 5% of the value of your estate. So think about everything you own, your house, your cars, your bank accounts, your investment accounts, everything you own, and take 5% of that right out of the pockets of your beneficiaries and into the pockets of the courts and attorneys and all of the people that need to get involved to liquidate your estate and get it ready to be distributed to your beneficiaries. So that's a huge sum of money that's just being taken away from your beneficiaries. And then, of course, another downside is that it's public. It takes a lot of documents filed with the probate court to administer your estate. Sometimes inadvertently, these documents can include social security numbers, bank account numbers, the addresses of your beneficiaries. But what it's definitely going to include is an inventory of your estate and who is going to ultimately receive what. So anybody can go pull that public court record and see how much money is in your estate and who's going to get it. It is a huge invasion of privacy, not only your privacy, although you're deceased at this point, but more than that, your beneficiaries' privacy. What happens if you have minor children as beneficiaries? Again, this is going to come back to that conservatorship scenario. The court will not allow minors to receive a large sum of money. So the court is going to nominate a conservator. We don't know who that person's going to be. If you've not done any estate planning at all, it's just going to be somebody selected by the judge. And of course, this person is going to want to get paid to be conservator. So that's more money every year coming out of your children's inheritance to go into the pockets of someone else. And that person will manage their money until they turn 18 years old. And then at 18, your children will get their inheritance outright with no oversight, no control to do whatever it is that 18-year-olds do with large sums of money. This can't be avoided if you die when your children are minors and the only planning you've done is a will or you haven't done any planning at all. The only way to prevent this from happening is through the revocable living trust. So how do you avoid probate and all of the downsides that come with it? It's through the living trusts.
Well, thank you. Yes, and I think we can all, one thing we can all agree on is 18-year-olds are not the best, thinkers of our planet. But and it's interesting because I mentioned that a lot of these things have happened to me. My uncle had passed away some years ago and lived in a tiny, tiny little house that my grandfather had built in 1924 in Hazel Park, and had like no keys. I thought he was dirt poor. And my mom's like, well, I got to go to probate. And I was like, I have to go to probate for under, like $20,000 or whatever. And it's like, oh no, he had a bank account with over $200,000 at the bank. And, of course, he was the only owner on it. So ended up 2 of my cousins who have had nothing to do with our family at all for over 30 years got each a fifth of his estate, and if he had just put a transfer on death on that account to his living siblings, he would have avoided all that. And it was just a nightmare over nothing. A simple document would have taken care of all that. Well, thank you, Michelle. We mentioned when we were meeting the family that they have a son that lives out in California, that they have a child with Down syndrome. And this workshop is not a special needs workshop. I just want to let you guys know that there are specialists that help families plan for children with special needs. So when you have a child or a grandchild that has special needs, and there's a lot out there, there are special ways to plan for those children. And we don't often want to just give them huge amounts of money outright, because that could disqualify them from certain government programs that they basically have to be poor to receive, but those programs are only available for people who have that. So like Down syndrome housing, like there's lots of special needs housing and things like that. So I encourage you, if you have a child or a grandchild in your realm that you want to do some planning for, you'll need an extra layer of special needs planning and an attorney that specializes in that and advisors that specialize in that and to help you. But it can be done and it can be very effective, and it's something I'm very passionate about, making sure that people take a little extra time to plan for that. The other interesting thing about when you have a child that lives farthest away, I often find that the children that are furthest away have the most to say about how mom is being cared for here locally when there's one of the siblings taking care of mom here, and we'll talk about that in a second. So now we're going to dig a little deeper into the family, and then we'll go into some more advanced topics as we're going to go back to Dawn, my evil twin. Yeah, so my mom, Dot, we are concerned about her because she is spending a lot of money on this boyfriend that's a lot younger than she is. And
Yeah, her husband passed away and she's got a lot of money, but is finding a way to spend it. And,
yeah, I've never seen anything like it. What do you do when your mom is blowing through all her money and is not listening to any common sense? I love giving things to my Hi, sweetie.
Hey, beautiful.
Oh, it's so kind to see you. Got a little surprise for you.
What about it? Ooh.
What do you say?
I love
Sure,
it.
you can find a way to pay me back.
I will.
Thank you. You gonna go drive it now?
I'm going to go take a little test drive.
Wonderful. And
you're trying to talk to her about it, right?
I try. She doesn't listen very much to me. Mom, I've been meaning to talk to you about, you spend a lot of money on this Dino guy, and just a little concerned about it.
Well, here we go. I had a little fun for once in my life when I spent all those years not having any fun.
I know, but I'm just worried that you're not, you're going to spend all your money and then you won't
He's worth it. What he does for me,
I don't want to know what he does for you.
he's priceless. He really
Your
is.
sister's living with your mom.
Mooching off the mom, and she doesn't do anything for her.
Well, she cares for her a bit, takes her to some doctor's appointments.
Yeah, if it's on the way to the bar, she'll do it. So, anyway, where am I living? Technically, I'm at mom's house right now because, I'm, as I mentioned, I'm in between opportunities, but I help out a lot around the house. So, and then I hope to get my own place soon. So as soon as I can find some work, I'll get a job and I'll get my own place. I think. Because I'm tired of hearing them have sex. It's not like hearing your 75-year-old mom having sex. It's just. Well, your dad lives with us now.
Yep, my dad's here. He's done really well. He's amassed a lot of wealth, and we really feel good about that. We're just concerned about his health. His memory's fading a bit, and you're just not sure how that money, if it's going to be enough to care for him, if he's going to have to leave us here, and maybe.
Yeah, I'm not sure when he's going to need assisted living. I mean, he's starting to get a little kooky. He thinks he's still in the Navy in World War II, and I don't know if we have the skill set to take care of that. I can't take much more. I can't. I'm gonna bust. I don't know what else to do. You're gonna have to pause this. I need a drink. Oh, and also, so the old man in that thing, it was my old man, and he didn't live with me at the time, but now he does live with me. So, but it worked out great, and we'll talk about that. So, Dan, guide us through some of the problems that we're seeing here.
Yeah, I think the biggest one is that, how are we going to protect our elders from taking advantage of, things going on in their environment and others taking advantage of them. That seems to be a big point of conflict, especially with the sisters. They do not agree on how much work is actually being done. one sister says, oh, she only drives her to doctor's appointments when she's going to the bar or when it's on the way. The other one seems to think she does everything. So there's a lot of, underlying tension there that could explode at any moment. And then one of the big things is, they're going to need assisted living. Talking about, the father-in-law, he's, still thinks it's World War II and he's in the Navy and he's having trouble with, function and keeping up with the day-to-day. And then, poor Debbie is sitting there in the house and she is, kind of stressed to the gills. She's not really able to handle with everything going on all at once, between, her daughter, father-in-law, her mom, there's just a lot she's taking on at once.
Yeah, we get that a lot, and especially women in their 50s who get the weight of their shoulders on their hand. I think, alcohol is a big issue for people. And we'll talk about maybe some of the strategies to help with that. So, as I mentioned, it's like, how do you protect yourself from yourself sometimes? So financial powers of attorney, Brian, we talked a bit about it earlier. Is there anything in like a scenario like this where we have, and I kind of made it funny because it's typically the older man with a much younger woman, but here I had an older woman with a much younger man. By the way, these are mostly clients of mine that chipped in to help out with these things. So this was a lot of fun to do. Is there, how do we protect someone from a Dino character?
Well, I mean, the biggest thing is like you said, get this financial power of attorney in place now before we have a problem in the future. While mom has a younger boyfriend right now, if she's lucid, if she's able to make those types of decisions and she wants to spend her money, you're not going to be able to prevent that from happening. But if you have a situation where she starts to go downhill, you don't want Dino stepping in and trying to convince her that he's the guy that needs to be making these calls. So you want to have these documents prepared early. You want to have them filed with the financial institutions, with your financial advisor, with your bank, to make sure that everyone is on the same page now. So when you do need it, you have it there. That's the biggest thing.
Yeah, and it's, the sad truth is that, like you said, if she's lucid, there's not a lot you can do.
No.
Like having those critical conversations with your family members to say, because mom's going to be like, hey, it's my money, I can do what I want.
Right.
And you have to, as a child, go, yeah, it is your money. I'm not entitled to anything. There's a sense of entitlement by some children that's like, hey, I want you to protect all that money because I want it.
Yeah. Doesn't work like that.
Yeah. And I think the key is communication, right? And so if Dot had that conversation with her daughter, say, hey, listen, the next 10 years, I'm going to woohoo, have some fun, but don't worry about it. I've got some assets set aside for you.
Right.
That, will be important. So, setting up those boundaries is really important, with each other and having this difficult conversation.
Absolutely.
But in the financial industry, as Brian and I talked earlier in the workshop about, and this having happened to me where someone else came in with the older person to the bank and kind of squeezed me out of it by him rescinding it. There are now newer rules on the books with financial firms, and we'll talk about them in a second, but signs to look for elder abuse are when someone is all of a sudden controlling the situation. That person's always on the phone, interrupting the person. If someone's been brought in to take care of the person and all of a sudden they're like, hey, let's call your bank, let's call your financial institution, things like that. Now, most financial firms have guidelines on this, and if we sense that there's something bad going on, we have some breaks that we can put in, where before we didn't. If a client called and said, hey, again, we had this happen, send all my money to this Russian orphanage. They need the money right away. They called me on the phone. Well, now, before I didn't have a lot of control over, I have to do what my clients tell me to do. Now there are laws to kind of back us up and help us not break our relationship with the client, but put a step in there so that we can step back and maybe prevent some form of abuse going on. And if you have abuse that you think is going on, you can report it. There's a hotline in Michigan, and they will actually send someone out to investigate the situation if you feel that there is something nefarious going on, whether it's a caregiver getting, it's not all financial abuse, it could be actually physical abuse. So please report it. And in our industry, if we think there is something going on, we actually have to report it. Dan, do you want to talk about a trusted contact? Because that's something that's relatively new in the financial world.
Yeah, so the trusted contact, that was a piece that was added a few years ago, and it's kind of multifaceted, but essentially what it does is it allows you to place someone as what's titled a trusted contact. This means this is someone, if your financial firm or bank is unable to contact you to confirm information or verify things, they can reach out to this trusted contact. They'll confirm personal information with the trusted contact, change of address, new phone numbers, things like that. So that can be good if they're trying to reach out to you and are kind of meeting a standstill there. They'll protect, there's a level of protection from fraud or financial exploitation, which is one of the things that we're discussing. It allows, the financial firm or bank to reach out and confirm that you want certain transactions put through, and just gives another step of defense from fraud. They can also confirm your health status if you are having any kind of mental debilitation or any kind of health issues that they are concerned about. They can confirm that with your trusted contact. And last but not least, they can verify the ID of your legal guardian, of your executor, your trustee, your power of attorney, which helps, again, battle against the large amount of elder fraud and elder abuse that we've come to see in the past few years.
So basically what will happen is you might have powers of attorney that, let's say, is your daughter and all this kind of stuff, but then you might have someone else as your trusted contact, so that that if you start doing wonky things with your account, they're going to reach out and say, you know what, Diane really needs, she's asking us to do some strange things. Can you please double check that she's okay? Because actually, bad financial decisions is one of the first signs of dementia. So, and dementia is a progressive disease, so it could take 10 years before you actually are seeing serious signs of dementia, but meanwhile, you're making very poor decisions on your money. So make sure you're adding trusted contact on all your investment accounts. Thank you, Dan.
No problem.
Right. So I want to kind of talk briefly about paying a family member to take care of you. So in this case, we have the sisters here, right? The good sister and the evil sister. And but neither, and both things are doing a lot of work and stuff like that. So having a written care agreement. So if Dawn is living with mom and providing care to some degree, maybe it's house cleaning, maybe it's taking her to medical appointments and stuff like that. What we often see happen is Dawn is getting paid by mom to take care of her. And then at the end of the day, when mom passes away and the estate then goes 50-50, Debbie feels resentful. She might say, hey, well, you got all that money from mom all those years. So having a written care agreement to say, hey, I'm being paid for these services, does it count, or does it count for or against your inheritance? I think is a really great thing to have a discussion. Again, as Brian and Michelle keep talking, while you're still here. Or one of my clients recently said, when I reach room temperature, and I was like, when you reach room temperature, what's that? And then I was like, oh no, that means you're dead. So while you're this side of the grass, make these decisions. And then of course, share this information with the other family members, because they don't have to like it, right? They don't have to, you're not going to make everyone happy if you have a complicated family situation, but they can understand it. So they can, at least you can just say, this is what I decided. You don't have to like it, but here it is. All right, and then assisted living. So is dad going to need care? I think it's really important to look at things now. Generally what will happen, I again know this from personal experience, is that you have a medical event, person ends up in the hospital, and then they're shipped off to assisted living for a couple weeks, or some kind of rehab, and then all of a sudden, a few weeks later, it's like, you need to find a place for dad or mom. So I think it's really important to run through those scenarios again while you're still cognitive and think about it. What do they want? Don't be shy about asking for help. I hate to put a plug in for an organization, but A Place for Mom actually helped me with my aunt and uncle, and they found me a place I never would have found on my own. And it was within the budget that we had laid out. So I was really kind of surprised at what a nice place they could get based on their budget. So, because if you live in our area, and like the Rochester area, you can't hit, every corner has an assisted living place now, but some of them are extremely expensive. But there are other alternatives for people. There are also special benefits out there for people who are like Navy veterans, like my father, who was in a World War II vet, Korean vet. There are benefits for them. And then Medicaid, you talk about Medicare and Medicaid. Medicare is a health insurance program, but it does not really pay for long-term care, nursing home care, things like that. Medicaid does, but you have to be poor. So whenever you see a term from the government that has the word aid in it, you have to be poor. And you have to have limited assets to get Medicaid. Michelle, do you know what the amount is for, like, how much you can have to qualify for Medicaid? You have to unmute yourself.
Yeah, yeah, it varies depending on what the Medicaid assistance is for and what whether you're single or married. But just as an example, for regular Medicaid assistance for a single person, monthly income can't exceed $1,063, and assets can't exceed $2,000. There are some exclusions when it comes to assets. For example, you're allowed to own a home, but if you have more than $2,000 in a bank account or an investment account, that's going to disqualify you for your Medicaid assistance. And the only solution to that is to spend down that money until you don't have it anymore. A lot of clients ask me, can I put my money in a trust and that way I'm eligible for Medicaid again? And the answer is no. The government has made sure that there's no loopholes to allow people to move their money into a trust and then have the government pay for their long-term care. There are certain things you can do with irrevocable trust, but it's difficult and it's limited circumstances. And really the only thing to do is fall under that asset limit threshold. So under $2,000 of assets and under $1,063 a month for a single person.
And what's interesting is we were looking at one place, and I said to the person at the assisted living place, if we spend on these assets, can I pick up the rest of the tab and let Medicaid kick in? And they were like, no, you'd have to move out of this beautiful facility, and you have to go into a Medicaid type facility that accepts Medicaid. And our goal for all our clients, and I know for Brian and Michelle and Dan, is not to have you have to go into a Medicaid facility. So it's not, it's not generally a goal of ours is to have you be so poor that you have to do that. I mean, we are a civilized society, so we have that so that no one is left on the street, but it's not always the most ideal form of care that we want to give to people. Brian, I hear a lot of clients come in and ask me about ladybird deeds. And if you could just briefly go through that, I'd appreciate that.
Yeah, ladybird deeds can be an effective estate planning tool if maybe you're not in a situation where you want a trust or need a trust. A ladybird deed, and that's the informal term for it, what we actually call it as an enhanced life estate deed. And on its basic terms, it's essentially creating a beneficiary on your home. What you're doing is that you are deeding the property, a life estate, to yourself, where you get to live in the property, sell the property, mortgage the property, do whatever you want. But assuming none of those things have happened, you are actually naming a beneficiary on it, where now that person owns the home after you pass. They would just need to, if they're going through the title process, they would just have a death certificate that says this person's deceased. This deed says that I am the owner of the property now. And the biggest thing is that it avoids probate. In terms of Medicaid planning, it can also be a useful tool because it isn't going to, if the house is not going through probate, the state can't come back and try to collect some of the money that they spent on you for your long-term care through Medicaid. So it's useful in that sense, and it's also useful just in general estate planning if you don't have a trust and you want to really avoid probate.
Great, thank you. And just so people know where the name Ladybird came from, it was for Lady Bird Johnson, LBJ's wife, and that she set up her so that she could remain in the property, and then once she passed away, it went to, I believe, Texas or something like that. Yep. So it was very interesting. So that's a Ladybird deed. All right, so we're just wrapping up now. There we go. I just wanted to touch on charitable planning really quick. Again, you want to plan this ahead of time. There are ways to give and receive at the same time. So things like a charitable remainder annuity. So you can give your favorite charity like Schoolcraft Endowment a chunk of money, and they will give you income for the rest of your life. And then upon your passing, that remainder amount goes to the endowment. This is a great year to do some charitable planning because normally if you give money to a charity, only so much of it counts against your taxable income. This year, 100% goes against your taxable income. So if you earn $200,000 and give away $200,000, you pay 0 taxes. That's very attractive this year. So good time to be looking at being charitable this year. Charitable bunching, because many people no longer itemize their tax returns. So because they've expanded that limit, but if you do have some assets, you can maybe gift them all in 1 year so that you can take advantage of the itemizing on your tax return. So I just wanted to bring that up really quick. So some key takeaways are, get your documents in order now. When's the best time to do this? Now. If you have documents in order and haven't reviewed them in the last few years, probably a good time to take a look at them. Dan, you want to talk about the next item? You have to unmute yourself.
The mute got me. Yes, so one of the big things that we see commonly is people think they've diversified because they have an IRA at 3 banks and 3 CDs at different banks across the town or city or wherever they are. That doesn't mean that you have a diversified portfolio. What that means is you have a unconsolidated portfolio, meaning your money is in multiple different places and it's going to be an absolute headache for planning reasons and for your heirs when those assets eventually pass on. What we always recommend is to have 1 IRA, 1 Roth, and 1 taxable account. Just have 1 place for those things, the retirement accounts with either your bank or your financial advisor, and having, 1 bank that you utilize for your savings and your checking and things along those lines, so that the transition of those assets is easier, doing your financial planning is easier, and you're not receiving statements from 5 different banks and financial institutions that makes you disorganized and doesn't allow you to really keep everything straight.
So we recommend that as you get older to just start getting it all in order. Your beneficiaries will really thank you. And
Right.
Make sure that all your assets are properly titled. If you have an IRA, make sure your beneficiaries are up to date. If you have a bank account that isn't in the name of the trust for whatever reason, at least make sure there's a transfer on death on every single account so that you can avoid probate. And I just briefly, I know we're at the end of our time, wanted to talk about your team because people often ask me, who should I go to first? A financial planner, our job is to help you quarterback everything, help you get everything organized, see where everything is. We are the global strategist for you. The attorneys draft the documents for you, make sure financial planners don't draft documents, but they're going to make sure that your documents are correctly designed for the state that you live on. Your CPA records history, typically, I jokingly say. So they're going to be the ones that file the tax returns. If a trust is no longer a living trust but irrevocable, it's going to have its own tax ID and have a tax return that goes along with it. So you want to have a good qualified CPA. And then a development officer, a charitable development officer, chief development officer, someone like Chris Kelly, it works at the nonprofit that you may be passionate about. He is going to help you figure out what's the best way to reach your charitable goals for the organization. So this is all part of your estate planning team to help you reach your goals. And then just in conclusion, I want to thank everyone. I want to thank Michelle and Brian, our attorneys, for chipping in today, and I think they did a great job. We can give them virtual claps. And Dan, for helping me put this on. We offer no obligation complimentary review. Typically, we're doing those via Zoom right now. So if you're interested in working with us, just let us know. Our contact information is there. And then I just want to find out if there's any questions. Chris, if you want to moderate any questions. Or Jen, whoever.
We have one quick one
Okay.
to the team. If someone has done a charitable vehicle, like a charitable gift annuity or even a charitable remainder trust earlier in life, do those assets affect their ability to take advantage of Medicaid if they are in that lower income area?
So if I'm understanding the question, they've already done a charitable trust in which the asset is no longer technically in their name. It's
Correct.
in the name of a trust. Michelle or Brian, do one of you want to take that? Whoever unmutes first. Oh, Michelle won.
I am not sure. Yeah, I'm not sure the answer to that. I don't know if Brian has an answer. I haven't done a lot of work with charitable remainder annuity trusts.
Yeah, I'm there with Michelle, unfortunately. It's just going to depend on the access and control of the funds. You know, they're going to have that income test. They're going to have the asset test. Medicaid planning is a very kind of niche area of estate planning. So I want to be careful not to give you any wrong information here. So I'm going to give you it depends, unfortunately.
Yeah, and the way I would read that is if they were getting income from an annuity remainder trust, the income would count.
Yes.
It's no longer in their name.
Right. So I don't think it would technically be an asset, but yeah, whatever income they're generating on it during their lifetime is going to be part of their general income.
It would go against that 1,063.
Correct.
Okay. Well, I don't see any more questions in our chat room. So I really want to thank the panel, Brian, Michelle, Dan, terrific job. And of course, Diane, financial advisor extraordinaire and award-winning actress. Thank you for sharing your expertise and in such an enjoyable manner. We're all going to reconvene on one of these again in October with another topic. So anyone who's interested, we'll keep you posted. Other than that, thank you for joining us and have a great day.
Thank you.
Thank you.
Thank you.